When you're acting as a professional deputy, though, the first thing that I say is read your court order, which sounds very basic, but the amount of times that's missed is rather surprising, because the court order itself will set out the specific powers and the scope of your authority. If you wish to read some case law, at the end of my slides, you'll see I've given you some case law, and RE-ACC is a really good case and a recent case that Judge Hilda lists what a deputy's authority should entail. And it's one of the first times you actually get a definitive list of what's within your generic deputyship powers. And so I always say read through your court order, but also check that case and see what comes into your day-to-day affairs. Because if you fail to comply with those duties, you could end up being revoked as a deputy and being removed by the Office of the Public Guardian. So it's the OPG that can make an application to remove you. They do the annual supervision of deputies. So you've got the Court of Protection that appoints you and gives you the court order, but the Office of the Public Guardian carry out the supervision. And in some cases, they will take things forward. So there's the Matrix Deputies case where they applied for the removal of about 42 deputyships from a company. On the basis of breaching their duties as professional deputies. They had all of their clients' money in one bank account for a kickoff before you even looked at anything else. They'd been taking commissions from estate agents and all sorts of things. And so they took it forward for the removal and to pursue that in the court. And so if you fail to comply, there could be some serious penalties thereafter. So we've got to be careful. We've got to know what we are doing. The other thing that I want to mention to you is what happens when P dies. Because when P dies, a lot of people just go, well, our authority's ended. Well, yes, but you were appointed by court order, so you actually need to be retired by court order. So you should send to both the Office of the Public Guardian and the Court of Protection a copy of the death certificate with a COP9 application asking to be discharged as a deputy. And you can then ask for your costs to be agreed with the executors, couldn't you, rather than have them fixed? So you can have fixed costs, assessed costs, or you can have them agreed with the executor. If your firm is the executor, that's not exactly going to work. But imagine it's family members. Well, that's fine, because it means you don't have to have them fully assessed. You can get them drawn up by a cost draftsman, submit that to the executors, and they can agree them. Okay, so these sorts of things are just things that are practical matters that people don't necessarily realise.